First of all, I'd like to welcome everyone virtually. If you can see me, I'm actually in my office. This is my first week and a half back in the office. It's good to be back, and it's good to be able to have this conversation with you regarding a very important topic, and a topic that really, it doesn't lend itself that well to a presentation, but I think I'm going to be able to pull it off tonight. But hopefully we can get through the material, we can get your questions answered, and we'll be able to get some really good information out there tonight. So what are we talking about tonight? We are talking about important issues to consider when amending the association's CC&Rs and bylaws. Now, amending the association's CC&Rs and bylaws is an issue that every community association should always have on the forefront of their minds. As I'm sure you are aware, the legislature almost every single year, obviously 2020 was a year when the legislature had a shortened session, but pretty much every year, the Arizona legislature sees fit to change the laws that affect community associations here in Arizona. And when the original CC&Rs and bylaws were drafted for many community associations in Arizona, they were drafted in such a manner as to be a one-stop shop for owners to understand their communities and all of the rules, regulations, and restrictions that would govern their particular community. So most of the CC&Rs and bylaws in existence are snapshots of the law regarding community associations that existed at the time the CC&Rs or bylaws were drafted. So if you have a 10-year-old set of CC&Rs and bylaws, those CC&Rs and bylaws are going to reflect the law as it was 10 years ago. If you have a 20-year-old set of CC&Rs and bylaws, those CC&Rs and bylaws are going to reflect the law as it existed 20 years ago. And as I just said, because the laws change almost every single year, inherently, the older your CC&Rs are and the older your bylaws are, the more chance that there are provisions in those CC&Rs and in those bylaws that have been negated by Arizona law. This creates confusion. If you have a provision in your bylaws that says, for example, that an owner may vote for the board of directors by using a proxy, the owner may come to the annual meeting and say, here are 20 proxies. I'd like to register my proxies. But the manager of the association will say, well, I'm sorry, Arizona law has negated your ability to vote with a proxy. And then the owner will come back and say, but section 7.5 of the bylaws say, and now we have confusion created. So it's very important that we try and evaluate our CC&Rs and bylaws, not only to bring them into concert with current Arizona law, but to also stand as a block to confusion that may be expressed by our owners that are reading these sometimes 20-year-old documents and thinking, hey, these are the rules of the road. If I follow these rules, I should be okay. So before we get into an in-depth conversation regarding CC&Rs and bylaws, let's first discuss what they are exactly. All community associations in Arizona have a set of what is generically known under the law as restrictive covenants. Now, these restrictive covenants can be titled many things. The Declaration of Covenants, Conditions, and Restrictions. The Declaration of Condominium, the Declaration of Covenants, Conditions, Restrictions, and Easement, the Declaration of Horizontal Property Regime, Covenants, Conditions, and Restrictions. there are a plethora of names for what is commonly referred to as restrictive covenants, or CC&Rs. About 5 years ago, the Arizona real estate statutes decided to give all of these documents, these restrictive covenants, a universal name. And that universal name is the Declaration. So in this presentation, what some people would call the CC&Rs, or the Declaration of Covenants, Conditions, or Restrictions, or the restrictive covenants, that document, for tonight's purposes, we're going to call it the Declaration. So Declaration equals CC&Rs. Okay. So the Declaration is the recorded document that explains to owners what they may and may not do with their property. All declarations must be recorded with the county recorder in order to be valid. And more importantly, all amendments to the declaration must be recorded with the applicable county recorder. The bylaws of the association is the operational document of the corporation, the nonprofit corporation that is the community association. Bylaws are typically not recorded with the county recorder, and therefore amendments to bylaws do not have to be recorded with the county recorder. Now, because these documents have two different jobs, the declaration deals with restrictive covenants and the bylaws deal with the nonprofit corporation, when you're looking at evaluating these documents for potential amendment, you're going to be looking at them in the guise of what job are they supposed to perform? Are they supposed to perform the job of restrictive covenants, or are they supposed to perform the job of governing the nonprofit corporation? If there are provisions, say, in the bylaws that discuss assessment collection, the job of the bylaws is not to place restrictive covenants on property. So if you have provisions in your bylaws that discuss assessment collection, they don't belong in the bylaws, because again, the bylaws only govern the corporate entity. Now, if you have in your CC&Rs a provision that says that the terms of board members are 5 years, that's an improper provision, because the regulation of the corporation should be contained in the bylaws, not the CC&Rs or the declaration. See, I even did it, the declaration. So again, the declaration discusses what you may or may not do with your property and the rules and restrictions bound on your property. And the bylaws discuss the corporate entity and how the corporate entity is governed. One of the most prevalent questions that I receive is, how often should the declaration and bylaws be reviewed for possible amendment? And the answer to that question is every 10 years. Now, why do I suggest every 10 years? Because as I said in my opening remarks, the date of the declaration and the date of the bylaws is a snapshot of the law as it existed on that date. So while we do receive changes to the laws pretty much every year, you want to aggregate those changes, because it is fairly difficult to amend the declaration and the bylaws. And we're going to discuss that in more detail shortly. But I suggest that if you haven't reviewed your declaration and bylaws and a 10-year span has elapsed, it's time to review your declaration and bylaws. So we're in 2021. Wow, I can't believe it. So if you have bylaws and declarations that have not been reviewed since 2011, it's time to review them. Now, when you're reviewing your CC&Rs and bylaws, you also want to pay very close attention to how these documents may be amended or amended and restated. So you may not have many changes that need to be made to your declaration or your bylaws. So if you have one or two changes that need to be made, you simply want to amend them. If you have 5, 6, 7 changes that need to be made, you want to amend and restate them. Also, if you're in a community association that has several amendments to their declaration or bylaws, so you're in a community association that has 5 amendments to its declaration already, it may be time to combine those amendments and create an amended and restated document. Why? Because it's much easier for owners to have one document than it is for owners to have 5 documents. Moreover, the tendency here in Arizona is to transition management companies every 5 to 10 years. And there are also a lot of self-managed associations out there. Sometimes these amendments get lost. Now, the good news is the declaration amendments are only valid if they've been recorded with the county recorder. So we can go to the county recorder and get a copy of all of those amendments to the declaration. Bylaws aren't recorded. So if you have 5 amendments to your bylaws and you can only locate 3 of them, we have a problem, right? But if you amend and restate your bylaws, then all of those amendments will be brought into one document, and one document is a lot easier to keep track of than 5, okay? But again, I want to reiterate that you take a look at your CC&Rs and your bylaws to determine how they can be amended. Specifically, the amendment threshold, and we'll talk about that shortly. Now, amending the governing documents can be a difficult endeavor because it's going to require the approval of the members. And, some community associations have a large amount of apathy, meaning, they're happy. They don't really want to be involved in the HOA. They want to watch the NBC game night game shows. And so they'll get information in the mail about the HOA and they'll just toss it. Some associations are very active, but it is a difficult endeavor to amend the governing documents because you're going to have several partners in order to do it. One of the partners you're going to need to have is your association attorney to look over those documents and to ensure that your documents will be up to date legally. Another partner is going to be your association manager. Your association manager is going to be the point person in regards to the process of actually amending the documents. And the board of directors is going to be a partner because the board of directors, they're going to be the cheerleaders for these amendments. So the board of directors are going to have to do most of the explaining to the owners as to why it is beneficial to amend the documents. And last, but certainly not least, the members will be an integral partner to this process because it's the members who have the vote to approve a potential amendment to the documents. Now, speaking of the members, you want to determine what membership vote is required in order to amend the documents. Now, it's all over the map. I've seen declarations that require a majority to amend. I've seen declarations that require 90% of the owners to approve them in order to be amended. The same with bylaws. I've seen bylaws that can be amended by a majority of the board members. And then I've seen bylaws that take 67% of the members to approve them in order to be amended. It's all over the map. So you want to make sure that you understand the amendment threshold before you get too deep into beginning the process of amending the documents. Now, if you live in a condominium, you want to pay special attention to the Condominium Act provision 33-1227A. 33-1227A sets a minimum requirement for the amendment of a condominium declaration. So if you live in a condominium and your condominium declaration says that it can be amended by a majority vote of the owners, it cannot be amended by a majority vote of the owners. Pursuant to the Condominium Act, it will take 67%. That is the minimum number that is required in a condominium to amend the declaration. Now, you can have a higher number. So if the declaration says it will take 75% to amend the declaration, then it will take 75%. But the lowest number is 67%. Now, this is only in condominiums. I say that with emphasis because sometimes people do get confused with this requirement. This is only in condominiums. Only in condominiums. Now, once you've determined what the appropriate owner approval is going to be, what you need, and then once you've had your documents reviewed by your association attorney, and once the board of directors has decided that it wants to seek an amendment to the declaration and the bylaws, then we can begin the process of actually amending the documents. Now, I want to go through that three-step process again, because I didn't make a slide on it. I should have, but I want to make sure that it's emphasized. The first step in the process is there has to be a will. So the board of directors has to have a will to want to review the CC&Rs and bylaws. I did it again, my apologies. The board must have a will to review the declaration and the bylaws to ensure that they're up to date. So the board's going to have to determine at an open meeting that that's something that the board wants to do. That's step one. Step two is once the board makes that decision that it wants to have the declaration and the bylaws reviewed, then the board should seek out competent, experienced legal counsel to review the declaration. Now, why do I emphasize competent and experienced legal counsel? One of the hardest things to do is properly evaluate whether a declaration and bylaws need to be amended. Because you have to know and understand completely Arizona Community Association law and understand how the various changes in that law, both statutory and case law, affects the declaration and the bylaws. This is not something that an attorney that has 5 years experience in medical malpractice can do. This is something that an attorney with 15, 20 years of experience should do, at least if you want it done correctly. Because it is so difficult to amend the declaration and the bylaws, and because you're only going to do it once every 10 years, the last thing you want to do is be cheap about it. The last thing you want to do is just go with any attorney that your manager refers to you to do it. Because if you make a mistake, it is very hard to undo that mistake. So you want to make sure you have competent, experienced counsel. You know, if you want to have an associate attorney with 3 years experience do your collections, that's fine. But when it comes to the operational documents of your association, you want to make sure that it's done correctly. So then the board expresses the desire, you go to competent counsel, and then it comes back to the board to determine, after the competent counsel has told you this is what you need to change, whether you want to move forward or not. Okay? If the board decides to move forward, now we get into the process of actually amending the governing documents. And that's where we are now. So there are several statutory requirements that need to be followed if you are going to endeavor to amend your governing documents. You should be aware of the meeting notice requirement if you're going to have a meeting. So if you're going to have an election meeting to vote on approving the amendments to the declaration or bylaws, you want to make sure that you abide by the proper meeting notice, and you can find those meeting notices in the Condominium Act and the Planned Communities Act as listed on the screen there. You also want to ensure that your voting ballot is in compliance with the statute. Now, a little, for those of you, and this is where this is what makes me sad. Because normally when I go into this part of it, I look out into the audience and I see friends that have been coming to the city of Scottsdale Neighborhood College for decades. And I see those friends and I feel good to see them again. And then I see new faces. When you're doing it via Zoom, I can't see your wonderful faces. But we adapt to our circumstances and we survive. But it's important to understand that you have to do the absentee ballots correctly. A little bit about myself for some of the new people that have heard me that are attending here tonight. I've been practicing law for 21 years now, and 19 of that has been in the representing community associations in Arizona. Half of my practice is defending community associations when they are sued. So when the community association is sued by an owner or another entity, they'll usually tender that lawsuit to their insurance carrier for indemnity and defense. And then that insurance carrier will hire a local experienced attorney to defend that association. My firm, we sit on several panels with several insurance carriers. And so over the past decade, our firm has grown into one of the largest firms that defends community associations. Why do I go into that little bit of a sidebar? I go into that little bit of a sidebar because I get to see when things go wrong. And then I have to use my lawyer superpowers to try to save the association when things go wrong. So what's the number 2 lawsuit that I defend in my practice? Election-related issues. Either the association didn't know or didn't care about the meeting notice requirement. Either the association didn't know or didn't care about the requirements of an absentee ballot. Maybe the association didn't understand fully when it had the ability to suspend an owner's voting rights and what notice is required to suspend someone's voting rights. So again, because it is so difficult to amend CC&Rs and bylaws, and because we're only doing this once every decade, it is imperative that it be done correctly. Because I have defended lawsuits where the association has implemented a rental restriction policy, no short-term rentals. And someone in a very high-end community in Scottsdale wanted to rent their property to Justin Bieber. And they rented their property to Justin Bieber and other celebrities. And the association said, hey, wait a minute, we passed an amendment regarding short-term rentals. And the owner said, sure you did, but your ballot wasn't correct. You didn't meet the requirements of ARS 33-1812 because this was a planned community. And sure enough, they didn't. They didn't meet the requirements of 33-1812. So what did the judge do? He threw the amendment out. Now, it had been about 5 years since that amendment passed. So the association went back to the members to see if they would approve the amendment again. And by that time, 30% of the association was short-term rentals. They could not pass it. So A lot of the owners in there thought, hey, now wait a minute. Whoa, hey, wait a minute. I bought my property with full understanding that I wouldn't be living next door to a short-term rental. Now the judge has overturned this amendment banning short-term rentals because the ballot wasn't done properly. Whose fault is that? Now fingers start to get pointed. Did the board seek legal counsel when it sought the ballot? Did the management company seek legal counsel? If they did seek legal counsel, did the attorney mess up? Fingers start to get pointed. And we don't want that. We absolutely don't want that. So when it comes to as I said earlier, reviewing the CC&Rs and the bylaws, and 2, preparing the ballot or the consent form, whichever way you're going to go. When it comes to reviewing the document and preparing the consent form of the ballot, seek experienced, competent legal counsel. This is a situation where it's just not worth trying to save a buck. Make sure that you've reviewed the statutes to determine the proper meeting notice. Make sure you reviewed the statutes and you've had competent legal counsel provide you with the appropriate absentee ballot. Again, I just want to give you another example of why this is important. I had a situation with an association in Northern Arizona. And again, a short-term rental situation where they were seeking to amend their CC&Rs to restrict, not completely forbid, but to restrict short-term rentals. So what they did was they sent out the absentee ballot, but they didn't send out the actual amendment. They didn't post the amendment on their website. They didn't post the amendment on the bulletin board. All they did was send out the ballot. Okay, the ballot comes back and the short-term amendment is approved. Rental amendment is approved. An owner challenges it and says, hey, all of these people didn't know what they were voting for because the association never sent out the actual amendment. So because the association didn't send out the actual amendment, the people didn't know what they were voting for, the amendment is void. Judge agreed with them. So you got to make sure that when you're amending your documents, you do so with the appropriate help. So let's get to 2 questions. With absentee ballots, what documents are required for commercial members to give proof who is the legal owner and who is allowed to vote the ballot? That's a wonderful question. That's a very important question. Thank you for posing it. Because there are a lot of units, especially here in Arizona, lots that are owned by trusts. They're owned by limited liability corporations. Some of them are held in REITs, real estate investment trusts. So it is important that you know who can properly vote that ballot. Now, I'm going to give you a sense of relief. The person that can vote the ballot is whomever the company or the trust says it is. So you don't have to worry about verifying whether John Smith is the manager of Shaw Real Estate LLC. If John Smith sends you a letter saying, I am the manager of Shaw LLC, then you can rely on that. Or if Susan Jones says, I am the trustee of the Shaw Family Trust, you don't have to challenge whether Susan Jones is the trustee. You just have to have a signed document that says that Susan Jones is the trustee of the Shaw Family Trust. So you just need a written document signed by the entity saying that they are the person that can vote, and then you can accept their vote. The second question was, what majority is required for planned community when approving updating declarations? Also, who approves the bylaws? Well, that is a question that can only be answered in the operable documents. So you're going to look in your CC&Rs and you're going to look for the amendment provision, and that amendment provision will tell you how many owners need to vote in order to approve the amendment. The same for the bylaws as well. There's a provision in the bylaws that will tell you how the bylaws can be amended. Again, this is where your competent, experienced attorney will come in to provide you guidance on how to do that properly. Now you have you're in the process of amending your documents. Now, what I want to do here is very high level analysis, because I'm going to pull back the curtain for everyone on this Zoom presentation. And I'm going to give you the top areas of declarations and bylaws that need to be amended. The top. So when I personally, and I have about 6 of them in my inbox, and if you're one of my clients that are waiting for me to to review your CC&Rs and your bylaws, I'm sorry, I'm just getting over my illness, and I'll get to it, but it takes a while. But the good news is, if you're listening tonight, you're going to get a sense of what I am looking for in your CC&Rs and bylaws. Now, again, this is not a comprehensive list. Magicians don't explain all of their tricks to their audience. Then magicians would be useless, and there wouldn't be a sense of illusion. But these are the biggest ones, the ones that I look at. I'll do usually a threefold reading of a set of CC&Rs. I'll go through this list here and look at these provisions. These are the low-hanging fruit, the easy ones. Then I'll go into a more in-depth analysis. But these are the provisions that, if you look into your own CC&Rs tonight when you get home, or maybe right now, you may have them next to you, you can look at these provisions and tell yourself whether you need to amend these or not. So let's start with typical declaration amendments. And let's start with real estate signs, open house signs, political signs, and children at play signs. Almost every single declaration created before 2015 is going to have a sign provision. And that sign provision is going to say, if you want to put up a real estate sign, you have to get architectural review approval, or you have to get board member approval. It's not going to say anything about political signs, but if you want to put up any signs whatsoever, you're going to have to get association approval. Well, the law has since changed. You no longer need association approval to put up real estate signs on your own property. Now, you can't put it in common area. You can't put it on common elements. You could put it on your own property. You don't need approval for that anymore. So if that's in your CC&Rs, that's a provision that may need to be revised. Open house signs, the same thing. Now, there's a specific statute for political signs saying when you may display them and when you have to cease your display. And just coming out of a very contentious political season, I had a lot of questions about political signs. I also had a lot of questions regarding what is a political sign and what is not a political sign. Now, that's clearly listed in the statutes that I've listed on the PowerPoint. So write down these statutes, because the answer to all of this is in the statute. There's no smoke and mirrors here. So you can clearly get the definition of what is a political sign, what is not a political sign from the statute. Children at play signs. I have a lot of kids in my neighborhood, but we have a lot of children at play signs. And there were some people on my own board that said, hey, you can't put that children at play sign in the middle of the street. You absolutely can put that children at play sign in the middle of the street pursuant to the statutes. So I'll look at the CC&R, the declaration, to determine the sign provision. So signs, that's a provision in most CC&Rs prior to 2015 that may need to be changed. Maybe some of these declarations after 2015 will have sign issues that don't comply with the statutes, and those will need to be changed. Second, antennas or satellite dishes. A lot of declarations will forbid satellite dishes. You can't do that anymore. And I gave you this is a federal statute. So I gave you the federal code regarding satellite dishes and antennas. So if you have a provision in your declaration that discusses satellite dishes and antennas, you want to make sure that that provision is in line with the federal statutes regarding satellite dishes. Solar panels and other solar energy devices. If you have a declaration that is older than 2015, then you will likely have a provision that will either forbid solar panels or will require architectural approval for solar panels. Well, the law has changed in regard to solar panels, and so those provisions of the declaration will need to be updated. And I just gave you the statute for the planned communities only when it comes to solar panels. Solar energy devices and condominiums are a case-by-case basis. Better to have your attorney give you advice on solar panels and solar energy devices if you live in a condominium. But if you live in a planned community and you have a provision in your declaration that discusses solar panels, it may not be valid anymore pursuant to the statute, and so that may need to be amended. Provisions regarding the parking of vehicles. Again, this is in planned communities only, but certain public service vehicles and public safety vehicles can be parked on streets or in other areas of the community pursuant to the statute. You may have a provision in your declaration that forbids on-street parking of any kind. Well, that provision has been replaced replaced by the statute. So that's a provision in your declaration that you would need to change. Provisions regarding attorney's fees. Under the statute, if you are seeking to collect assessments, reasonable attorney's fees are included in the assessment lien. Some CC&Rs may not even comment about attorney's fees, or some CC&Rs may have a different explanation of how attorney's fees are to be awarded. I have a client that says that no party gets attorney's fees regardless of who wins. I have a client who had a set of CC&Rs that didn't discuss attorney's fees at all. So you want to look in your CC&Rs to look at the attorney's fees provision and make sure that they match the statute. Provisions regarding mandatory insurance. I had a question today regarding insurance for a community association. And a lot of condominium associations are not aware that the Condominium Act places a requirement for minimum coverage of buildings and units in the Condominium Act. So if you have a condominium declaration that says that all you need is $1 million in replacement costs, so if the condominium burns to the ground, your CC&R say that all you need is $1 million. Well, the statute says that you are required to have enough insurance to cover 80% of the replacement costs. If you live on a golf course condo in Scottsdale, $1 million is not going to cover the 80% of the replacement costs. And if that board of directors, either through ignorance or through the fact that they're not looking at their CC&Rs, didn't know of this requirement, there's going to be problems for that board of directors. So when I look at condominium declarations, I will go to their insurance provisions. And if it says $1 million is all you need, I go to their manager and I say, how much do you think it would cost to rebuild the condominium? And if she says, oh, $2 million, then I amend the insurance provision in the CC&Rs. So those are some common declaration. I keep doing it. I apologize, guys. Those are some common declaration provisions. The most common that I look for when it comes to amending declarations. Obviously, there are many more, and it's hard to create a comprehensive list. because, declarations are like art. They're all different. And so, one Picasso drawing may not look like another Picasso drawing, but they're still Picassos. So, it's hard to create a comprehensive list, but those are kind of like the top ones that you'll see, and they highlight why it's important that you have your declarations reviewed. Now, we're going to have more in the bylaws section of this. And the reason why we're going to have more in the bylaws section of this is because over the past decade, the Arizona legislature has been more involved in the business of community associations than in the restrictions of community associations. So because the legislature has been more active in regard to how community associations run their business, there are a lot of changes in the bylaws. I recommend that everyone listening to my voice have their bylaws reviewed if those bylaws have not been reviewed over the past 3 years. There will be changes. So let's go through them. The first thing that you're going to want your competent attorney to understand, and this is something, unfortunately, that a lot of attorneys don't understand, and that is you want to make sure that the bylaws do not conflict with the Articles of Incorporation. In Arizona, there's a hierarchy of documents. Now, if you live in a condominium, this hierarchy of documents is statutory. It's in the Condominium Act. If you live in a planned community, this hierarchy of documents is based in case law. So the most important document is the declaration. Coming in second is the Articles of Incorporation. Coming in third is the bylaws. So if there is a conflict between the bylaws and the articles will prevail. A lot of young attorneys don't understand that or don't realize that, okay? Why is that important? Because the Articles of Incorporation are the throwaway document. They're the birthing document of the association. So when you're going to create a community association, you draft up a set of Articles of Incorporation, you file them with the Arizona Corporation Commission, and then you forget about them. Because what you do after you file your Articles of Incorporation is you create a set of bylaws that, if drafted properly, incorporate all of the provisions of the Articles of Incorporation. But during the developer boom in Arizona, a lot of the developers out there, they didn't care about legal formalities. They cared about creating communities and turning a dollar. So when they created their bylaws, they neglected to incorporate provisions of the Articles of Incorporation into the bylaws. So what are the big three? One, how many members can be on the board of directors? The Articles of Incorporation will speak to how many members will be on the board of directors. So are the bylaws. If there's a conflict between the articles and the bylaws, the articles will prevail. If the association didn't understand that, and the articles say that there can only be 3 directors, and the bylaws say there can be 5 directors, and some smart lawyer sues the association and says, not only do you have too many directors, but every decision that you've made, especially when it comes to foreclosing my home for failure to pay assessments, is invalid because your board is invalid. And the court says, yeah, don't you guys know that the Articles of Incorporation are going to trump the bylaws and you can only have 3 directors? Don't you know that? And the board says, no, we don't. Now you're in trouble. And that's a real example. It's a real example. So the first thing that I do when I look at a set of bylaws is I ask the client, hey, do you got a set of your Articles of Incorporation? And I match up the 2 to make sure there are no conflicts. Second thing I do is I take the bylaws and the CC&Rs, now the declaration. Now there shouldn't be any conflicts between the bylaws and the declaration because they do 2 different tasks. Remember, they have 2 different jobs, but sometimes they do conflict. So experience has taught me, look at the bylaws and the CC&Rs as well. But you definitely want to look at the bylaws and articles to make sure there is no conflict between the two. Let's run through these provisions that the top provisions that you want to look at. First provision you want to look at is annual and special meeting notice. Make sure those provisions are in line with the statutes, and I provided you with the statutes. Provisions regarding board meetings. The statutes have a lot of detail when it comes to board meetings. So do the bylaws. So you want to make sure that the bylaw provisions match the statutory provisions word for word. Now, I've provided you with the statutory provisions, so all you got to do is just, cut and paste pretty much. But when you're looking at your bylaws, you want to look at the board meeting provisions and make sure that they are in compliance with the statutes. Records requests. Records requests are governed by the statutes, period. They negate and overturn any provisions found in the bylaws. I just did a bylaw review today that had a records provision in it, a records request provision in it, and I took it out of the bylaws. And I explained to the client, there's a statute that discusses records requests. It's in conflict with your bylaws. It overturns your bylaws. So delete this part of your bylaws and go with the statute. Now, we should all know this because it's been about 15 years since the statutes negated proxy voting in Arizona, but there are still some bylaw provisions, as I said in my opening remarks, that state that proxies are allowed. They are not. So in order to avoid confusion, we want to take all of those proxy provisions out. There are also provisions regarding absentee ballots or consents or mail-in ballots, any of that type of language in a set of bylaws. As I spoke on earlier, absentee ballots are strictly related by the strictly regulated by the statutes. So provisions regarding the voting, the drafting, the dissemination of absentee ballots in the bylaws, you want to look at the statutes to make sure that they're in line. You don't want any conflict. Again, the number 2 lawsuit I see in my office regarding insurance defense is election-related issues and meetings-related issues. It's complicated. And, there are, a lot of, I hate to say it, but there are a lot of younger attorneys that don't, when you say to them, hey, look at the, review my bylaws for me, they haven't fought the wars in court to understand that, hey, you really want to make sure that the provision of the bylaws matches the statute so that you don't have to litigate it. If the bylaws match the statute, there's nothing to litigate if you follow the bylaws and the statutes, obviously. So you want to place the association in a position where the bylaws do not create litigation. You want to put the association in a position where the declaration does not create litigation. In order to do that, you have to have seen the litigation that it could potentially create in order to avoid that. This is a big one. The removal of board members. 4 years ago, the statute completely overturned any bylaw provision regarding board member removal. Any bylaw provision regarding board member removal. The only provision that survives is if the bylaws provide the board of directors through a majority vote to remove a board member. That survives. But any removal of a board member by the members is now governed by statute. And I can't guarantee anything, but I will bet good money that all of your bylaws have a removal provision, and I will bet good money that they do not comply with the statutes. So I've given you the statutes. Provisions regarding the replacement of a removed board member. How can you do that? That's also in the statutes. So you want to make sure that you bring your bylaws into sync with the statutory requirements for replacement of a removed board member. Next slide. I want to end the presentation by saying I am very energetic and enthusiastic about this topic, because although I'm very good at it, I kind of don't like doing it. And the reason why is because if we just work together in this, we can come to a situation where we do this every 10 years, it's once a decade, and we go on. I dare to say that boards should start to build a budgetary line item for the review of their governing documents, policies, and procedures, so that it doesn't come as a shock to you. Again, being proactive in reviewing your declaration and your bylaws is a litigation mitigation strategy. It's a litigation mitigation strategy. It also alleviates confusion amongst your owners, and it's also going to provide you with the best business practice in regards to operating your association.